Welcome to the Professional Development Series. My name is Chris Fortier. I am the chair of this series for the PSB's Young Lawyers Conference. I'm proud today to bring in a speaker who spoke at our 2013 Professional Development Conference in Washington. Lesley Marlin is an employment lawyer for General Dynamics Information Technology, GDIT. She's here speaking in her personal capacity, not as a representative of GDIT. Prior to going in-house with GDIT a little over a year and a half ago, she worked for over 8 years at a law firm where she concentrated on her practice in labor and employment law. In private practice, she counseled employers on employment policies and decisions, advising them how to comply with various federal, state, and local employment laws. Before private practice, Lesley was a law clerk to the Honorable Robert G. Dumar in the Eastern District of Virginia in Norfolk. Back in 2009 and 2010, she served as the president of the Virginia State Bar Young Lawyers Conference, where she led an initiative to develop a legal handbook for cancer survivors. In her non-work time, Lesley served on the board of the Went Center for Loss of Healing and volunteers at the Colon Cancer Alliance and Immerman Angels. She's also the mother of twin boys. Lesley, the floor is all yours.
Chris, thank you so much for that kind introduction. I'm delighted to be here to talk about sort of performing exceptional work. In my opinion, the key to exceptional work is service. Law is a service industry, and so our focus is on our clients and serving our clients, and that's why the theme of what I'm going to talk about today is really service, service, service. It's really focusing on service. So briefly, I wanted to talk about give you an overview of where I intend to go and kind of what our purpose is. I want to briefly explain my background because I think it kind of provides a framework of where I'm coming from. I want to provide appropriate disclaimers, and then I want to offer an approach of what I believe really constitutes sort of effective client service. So briefly, with respect to sort of my background, I went to the University of Virginia as an undergrad, went straight through to law school because I thought I wanted to be a prosecutor. I tried that in law school and learned it really wasn't sort of the right fit for me, which is then when I went to sort of clerk, and it was when I was clerking that I sort of discovered that I really liked employment law. It was a substantive sort of area of law that I could learn and develop an expertise in. It also was going to allow me to sort of have a practice that was a mix of litigation as well as counseling and advising. So after I clerked, I went into private practice at Venable. I was there for about 8.5 years. I practiced labor and employment law exclusively. As Chris said in my brief introduction, my clients were kind of all various sizes and in different industries, and I was, in 2009, 2010, the president of the Young Lawyers Conference for the Virginia State Bar. So I'll just take a brief aside and give a quick sort of plug for the Young Lawyers Conference. It is a tremendous organization. You'll often hear it referred to sort of as the service arm of the bar because there are so many great pro bono projects and public service initiatives that are run by the Young Lawyers Conference. It is also a great opportunity to meet and connect with other young lawyers across the Commonwealth of Virginia. And as a lawyer, especially in a large law firm, which was me, getting to meet lawyers in a variety of different, not only substantive practice areas, but different types of practices, much smaller firms and even solo firms, really sort of helped give me a different perspective and helped sort of bring me back. And even when I was having sort of difficult days, weeks, or months, would sort of remind me of why I became a lawyer. So that's kind of my plug for the Young Lawyers Conference. So as my years went on in the firm, if I was completely honest with myself, and we're going to talk about that in a little bit, I realized ultimately that I didn't want the responsibility of building a practice and bringing in business. And so that's when I started looking for kind of the right opportunity. Thankfully, I had sort of the luxury of time. And eventually, I found that right opportunity with my current position coming in-house with General Dynamics Information Technology. as luck would have it, I found that opportunity at what seemed like the worst time. It was the beginning of 2012. I had just been promoted within the firm, but even sort of more importantly than that, I was just finishing the end of my first trimester being pregnant with twins. So I say all of that really to show that some of the career path and track that people take, for me, is really about being open to opportunities, even though I didn't really think it was the right time. So in my current role in-house, I have two real distinct roles. I am sort of the client in many times when we are using outside counsel, which I know is one of the reasons that folks sort of propose that I might speak. But more importantly, and even more primary, I am a lawyer. And I have clients and I represent clients. And that component of law being a service, industry, and profession is really paramount in what I do day in and day out. Even sort of, first thing this morning, late at night, it really is a service profession where we need to be responsive to our clients. So that's enough about me. Let me turn to sort of my disclaimers, as any good lawyer would have. As Chris mentioned in the introduction, I am speaking only sort of in my personal capacity and not on behalf of my employer at all. And the approach that I'm going to offer to effective client service is really an example or a suggestion. It's what has worked for me, but it is not the only way to provide effective client service. There are many ways, but this is just one of them. So with that, I want to turn to sort of outlining my approach. And my approach is WA. And before I sort of explain WA, and it's listed here on the slide, I want to give you a history of how I came up with WA as this approach to effective client service. In my role as a lawyer and as an employment lawyer, I often am given a claim and called upon to investigate that claim and defend against that claim. As part of investigating a claim, I need to get the facts. When I was clerking, I remember very distinctly that my judge, he would repeat this often, would say that facts win cases, not law. And so that has really shaped the way I practice, because when I'm defending against a claim or I'm in litigation, I try to focus on the facts. If you can tell a story, it is more compelling to tell a story and have the reader or the judge or the jury reach the conclusion that you want them to reach than it is to simply tell them the conclusion. So as I'm investigating, whatever claim I'm working on, I'm acting like a reporter. I'm asking questions like who, what, when, where, why, and how. Those are the questions that a journalist or a reporter is going to ask if they're trying to get information to report on their news story. It is the same approach that I take generally when I'm working on a case. And I think if we can take that concept and apply it generally when we're talking about sort of effective client service, because I think if we answer all of those questions, we are going to have created a framework that enables us to provide effective client service. So I want to break down each of these and spend a few minutes talking about them. With respect to effective client service, the who piece, there are two different aspects. Who are you and who is the client? So let's first talk about who are you. And this is where I referenced earlier the importance of knowing yourself. It is important as you develop your own practice and career to define your own style and voice. And that is you can pick up pieces from other people. You can, watch and observe. You need to sort of figure out what works for you. There might be a really effective lawyer that you see in a courtroom who does something, but it's just not going to work for you because that's not who you are. And I think you need to sort of know yourself to be able to figure out, yes, I could do that, or no, I couldn't, or that would work for me, or it wouldn't. This is where I think that mentors can be really invaluable. And I should probably pause for a moment and define what I mean by a mentor. In my opinion, a mentor is someone that you have a professional relationship with who you respect as a lawyer. That to me is a mentor. It doesn't have to be something that you have formalized where you've gone to them and said, will you be my mentor? And they've agreed, because that's quite frankly awkward and doesn't often work in many situations. But it's really, again, in my opinion, a mentor is someone that you have a professional relationship with who you respect as a lawyer. Those are the people that you are watching and learning from and picking up on things and saying, yeah, I like how they do that. I think I'm going to adopt that. Or, no, I don't like that. I'm not going to do that. That's where mentors can be really invaluable to you. I want to sort of suggest a brief exercise. I think that it is incredibly helpful. This is something that someone shared with me very early on in my career, and so I want to sort of pass it along. And the exercise is this. I want you to take a regular piece of paper, an 8.5 by 11, and hold it horizontally and then fold it in half. On the left side of the piece of paper, I want you to spend, 2 to 3 or 4 minutes writing down the first things that come to mind when you're asked the question, how would colleagues or clients describe you? That's currently as it exists today. Then I want you to, on the right side of the paper, spend another 2 to 3 minutes writing down the first things that come to mind when you're asked the questions, how do you want your colleagues and clients to describe you? And then once you've done that, spend a few minutes looking at what you wrote on the left side versus what you wrote on the right side. Are they the same? Are they different? How are they different? And in what ways? And then if you have someone that you are, a colleague, a friend, a mentor, share that with them and see what you can sort of gain from each other's experiences. This exercise is different than an elevator speech. So for those of you who've taken any classes or training or workshops on business development or rainmaking, there's this notion of an elevator speech, and that means that's the 30 second, 1 minute statement that you would make if you were meeting someone in an elevator that would explain what you do and why you could help them as a lawyer. This is different. This is really focusing on how people would describe you as a lawyer and then how you want them to describe you. I think this exercise is invaluable because it helps you figure out kind of your strengths and weaknesses and gives you things to work on to develop yourself, personally and professionally. I would suggest revisiting this exercise kind of over time, whether it's every year, every couple years, because your answers can change over time. And I also think that this exercise is a great discussion topic to use with a mentor. If you are really wanting to develop sort of a mentor-mentee relationship with someone, as opposed to sort of saying, will you be my mentor, I think this is a great way to go about facilitating that connection and relationship where you can really, gain some valuable insight and learn. Now that I've sort of shared that exercise, I want to briefly give you what I come up with when I do this. And I have, over the years, spent a lot of time trying to make sure that the left side of my page matches the right side of my page. And so for me, and I thought I would share these in the event that they're helpful to anyone so you can see how it might look. For me, how my colleagues and clients describe me and also how I want them to describe me is 3 things. The first is I want them to know I'm a labor and employment expert. I want them to know that I know that area of the law and that I can help them with their problems in that area. Second, I want them to know that I'm a partner of theirs. And that really has a couple of different components, and I'll come back to that in a second. But third, I want them to know that I'm a human being. And why is that? I want them to be able to connect with me personally. I think that if you are able to connect with your clients personally, you have a more effective working relationship with them. That means that they need to see you as a human being. None of us are perfect. We all make mistakes. If they can see you as a human being, you are more likely to sort of have that kind of deeper, professional relationship, and they're more likely to really sort of respect you as a lawyer. So back to the partner piece. I want my clients to see me as a partner for a couple of reasons. They need to know that I'm available and responsive to them. As I mentioned at the beginning, law is a service industry, and as a service industry, we are going to, whether you're in private practice or even in-house, quite frankly, only going to be able to get clients to come to you if you are available and responsive. In private practice, if you're not available and responsive, they go to someone else who's available and responsive. In-house, if you're not available and responsive, they just do whatever it is they want to do, and they won't check with you. I want them to engage me, and so I need to make myself available and responsive. I also want them to see me as a partner, and that means providing practical solutions. That's the what does the law say versus what does the law allow versus how can the law help me achieve my objectives. And I think you need to understand what your client's objectives are in order to be able to give practical solutions. If you don't give practical solutions, what will happen? Again, they'll stop coming to you. And that's true whether you're in private practice, or they'll go to someone else, or in-house, they'll just stop coming to you. Also, as a partner, I want my clients to see me as an effective communicator, and that's both, verbally when we're talking on the phone or in meetings, and that's also in writing, whether it's formal letters, documents, memos, or even just email. And I want them to see me as an effective communicator, because if they think that I can't get to the point or I can't explain it well, again, they're going to stop coming to me, and I'm not going to be that partner that I want to be. So these kind of three things of who I am as a lawyer really leads me to sort of my overarching motto when dealing with clients, which is under-promising and over-delivering. And that's really about setting expectations, managing those expectations, and then not just meeting those expectations, but exceeding those expectations, because that's what leads people to think that you are providing them great client service. So that's the who are you. Now let's talk about the who aspect, where we're talking about who is the client. I think you need to identify the client, and the reason you need to be clear on that is because it has a whole bunch of ramifications. It has ramifications for, whether the attorney-client privilege attaches. It has ramifications for how you interact with that individual or entity, as well as the representations that you make to that individual or entity. Client can be both official or unofficial. So unofficial clients are people like partners, senior associates in law firms, your boss in-house or working for the government, whoever it is that is sort of tasking you with the assignment or the work. That's an unofficial client. And as with an official client, it's important to keep even those unofficial clients happy. And in fact, sometimes those unofficial clients may even be sort of your primary audience or client. Then there's your official client. And often there is a distinction between individuals or entities. Because of the nature of my practice, I almost exclusively represent entities. When I was in private practice, that was almost exclusively companies, nonprofits, etc., as opposed to individuals. Now that I'm in-house, obviously I have one primary client, which is the company, but then I have a whole bunch of unofficial clients. Not only, the human resources representatives and officials, but senior management within the company, the various different levels of operational management depending on the matters that I'm working on. So I have lots of unofficial clients, and all of those people are people that I want to sort of keep, satisfied and engaged so that they keep engaging me. Once you've identified the client, I think you need to spend some time knowing the client. And that's, learning their idiosyncrasies, of course, but that's also knowing them as a person, knowing kind of what really drives them. Put yourself in their shoes. Everybody sort of has this, radio station, if you will, that they're tuned into. And if you were reading my columns when I was president of the Young Lawyers Conference, one of them that I talked about in one of the columns was this notion of WIFM, which is what's in it for me. That's putting yourself in the client's shoes. What's driving your client? What does your client want to know? What keeps them up at night? What are they concerned about? If you think about how you can help this person, that is driving you towards providing them with effective client service. When I was in private practice, a lot of my clients were really not just worried about the claim or issue that they had come to me about, but also more broadly, they were worried about sort of how it was going to reflect on them. If there's an employment claim that's come up against a company, again, even if it's not in formal litigation, but it's just at a demand stage, they're worried about how that's going to reflect on them. Their performance is being evaluated, and how is that going to impact how they are viewed. And so if I could help them not only deal with the claim at issue, but I could help them make them better at their job, I became invaluable to them. And that's providing effective client service. So it's thinking about how you can help them not only with the issue, problem, or situation right at hand, but also more broadly, whether that's professionally or personally. And the more you get to know someone, sometimes it can be sort of on the personal level. If they've got a situation going on in their personal life, how can you help them? How can you connect them to the right resources that they might need? How can you sort of assist them? And as I said, it can also be, and often probably more likely is professionally. How can you help them make them better at their job? Okay, so that's the who. That's the first W. Let's turn to the second W, which is the what. When we're looking at trying to provide effective client service, the what is the project, task, or assignment at hand. Understanding what the issue, concern, or problem is. That way, you can figure out what you need to do to get it addressed. It is important for you to think about what the end product is going to be. If you can't envision what the end product is going to be, how are you going to know how to get there? So oftentimes it's thinking about what's my end product going to look like, and then working back from there. And especially with larger projects or larger assignments, sometimes you've got to do that. You've got to figure out what the end goal is, and then what are all the interim steps? Because otherwise, if you look at the whole thing, it becomes overwhelming. At least for me, it does. So I need to break them down into smaller chunks, smaller steps, smaller action items, and then I can sort of one by one check those off my list. With the what's the project, task, or assignment, you need to do your own homework. If the topic is new to you, the area of law is new to you, research it, learn it, spend some time, become an expert in it. There is no sort of shame in admitting that you don't know something, but that's also not an excuse for not knowing it. By way of a quick example, I'd spent a lot of time learning in private practice the hospitality industry because I had done a lot of work in that. I also worked a lot with different nonprofit organizations and retail establishments. I knew very little about government contracting. And then I got this job in-house, and I work for a government contractor. So what have I been doing since I joined the company? I've been trying to learn as much as I can about the various different types of government contracts, the terminology that's used, understanding the lingo, trying to understand some of the government contracting laws. I will never be an expert in contracts or government contracting because it's not my area, but at least I know enough about it now so that if those buzzwords are being tossed around, one, I can understand them, but two, I can understand the business side of things so that I can fit my legal advice into that frame of reference, so that if I'm talking with folks who don't speak my lingo in terms of labor and employment, I can speak more their lingo. I can put it in terms that they will understand. When you're looking at your project, task, or assignment, it's very important if you are confused or don't understand, what somebody has asked you to do, again, whether it's an official or unofficial client, ask appropriate follow-up questions. And that can be, at the time you're discussing the task at hand, but that could also be later. Just a quick word about multiple projects, tasks, assignments, dealing with all those simultaneously. All of us have to do that on a daily basis. I think the best way to do it is to triage and to prioritize and deal with the most pressing things. I come into the office every morning and I have sort of a set agenda of what I hope to accomplish that day. Occasionally, and rarely, I'm able to spend my entire day doing exactly what I had hoped to do. That is rare, though, because, again, I'm in a service industry, and so I'm here to be responsive to my clients, and issues come up. And what I need to be able to do is triage them and figure out what are the most important issues. The ones that have got really urgent, critical needs to respond to get responded to first. The ones that can sit on the back burner a little bit more. And then, if all goes well, I get to what I was hoping to for that day. So that's the what. Let's turn to the when question. The when is this project, task, or assignment needed? I think if you haven't been sort of told by your client what the time frame is, that's an appropriate and important follow-up question to ask. What's the time frame? When do you need this? Is there any flexibility on that? Once you know that, you can then, again, work backwards from that sort of deadline to create the timeline that you need to get whatever it is done that needs to be done. If you have any sort of luxury of time, build in extra time. So, for example, one of the things that I, do in my role is here for the company is respond to employment claims that have been filed with the Equal Employment Opportunity Commission or other similar state agencies. I get my deadline from the agency. Once I know that, or I ask for an extension if I need it, once I know my deadline, I then work back. And my own internal deadline is to have a draft of that document done at least 1 week before I have to submit it, so that gives me time to circulate it to my clients, to get them to review it, make sure it's accurate and complete, and to make any changes that are needed. That builds in the extra time. It gives my clients time to review it, but also allows them sort of some flexibility as well in getting back to me. And that building in extra time is important because this happened to me, it happens routinely. If you send something to a client and you're expecting them to review it right away and they're on vacation, and you didn't know that, and you hadn't had a discussion about the time frame, you're not going to be able to get a response. Or if you do get a response, they're going to be really aggravated that you're interrupting their vacation. So if you can have that discussion about time frame up front, that's really going to help you figure out sort of what you need to do to get your project, task, or assignment done. With respect to sort of giving documents to review to clients. And this kind of works both ways. It works with, my external client, or my outside counsel giving me documents to review when they're representing us in matters. But it also works with me giving them to my clients to review. I think sort of the the general rule that I try to follow is treat it as you would want to be treated. So if you don't want to get something Friday at 5 o'clock, try not to be sending something to someone else Friday at 5 o'clock. Because I think over time, if you treat people in the way you want to be treated and send something to somebody to review and give them enough time, you hopefully will get that back in return. You want to sort of manage those time frame and timeline expectations as you're going along. Just a quick word about responsiveness. My rule of thumb is to respond in some way within 24 hours. And that's to voicemail, email, whatever, text, instant message, whatever the case may be. And text and instant message are even sort of higher priority, so those are probably even faster than 24 hours. And that's response of some kind. That may not be a substantive response. That may not be I'm coming back to you with the answer to the question you asked me, but it may simply be saying, yeah, I got your email, I'm going to look into it, and I'm going to get back to you. But then following up and saying, I expect to be able to get back to you tomorrow, in a couple of days, in a few weeks. It's setting the expectation of when you're going to get back to them. And again, under promise and over deliver. So if you say you're going to get back to them within a few days, get back to them in a couple of days if you can. If you say it's going to be a week, get back to them in 3 or 4 days. Just giving them an expectation of when they can expect to hear from you more substantively it is important, and at least they know that you're tied up on other things. You don't need to explain why you're tied up. You don't need to even say you're tied up. Got it, working on it, we'll get back to you by whatever time. I have routinely been doing this. I think it probably comes from my clerkship days when my judge sort of had sort of the 24-hour rule. But it was very interesting to me within the last month or two, a client of mine, an unofficial client within a company, said, I sent an email and said, got your emails, working on it, going to get back to you, tomorrow, I'm tied up today, I'll get back to you tomorrow. So when she and I had a conversation the next day, she said, I have to really tell you, I really appreciated that. And I said, I'm so sorry I wasn't able to get back to you yesterday. And she said, no, you've really taught me something. I know what to expect from you. I know you're working on it. I know you're going to get back to me, and you follow through. She said, I've started, sending emails to people saying, I'm working on it, I'll get back to you by X, and she has sort of adopted that practice, and she thought it was really effective and said, thank you for teaching that to me. So I think it can be really helpful, again, which is why I pass it along. And then the last point on this, Wen, is just making sure that you have that ongoing communication. If you say you're going to get back to someone tomorrow and something comes up, sending them an email and saying something came up, I got, an issue that I had to deal with, I had an emergency, here's my new sort of time frame. And sometimes I will say, is that okay to a client? Sometimes I will say, I hope that's okay. I trust this is all right. So sometimes I'll ask, and sometimes I'll just, sort of state it affirmatively as an assumption, and that, I hope that's okay. So that's the when. Let's turn to the where. When we're talking about effective client service, the where question is about where is the issue or concern that you're working on? What jurisdictions? What sort of that question about what jurisdictions or where is important because it drives what law applies, what law governs. If we're talking about an employment issue in California, for example, and I don't know that these employees are in California, and I'm just looking at federal law, that's not going to help me. I need to be able to also look at California law to know what laws kind of apply and are going to govern on that issue. So again, being very clear, if you don't know where the issue or concern you're looking at is occurring, asking that where question is an important follow-up question. With where, the jurisdiction, and then what law applies or governs, I want to spend just a couple minutes talking about research considerations, because a lot of what we do as lawyers, regardless of practice area, is research. especially the more junior that the lawyers are, tend to sort of spend more time doing research, but I'm not immune. I do research myself. Especially if you're in private practice, one of the things you want to make sure, but even in-house, is are there any restrictions on sources? What resources do you have available to do research? The resources that I have available now are different than when I was in private practice. When I was in private practice, the restrictions on sources were different. What is the cost of those sources? What are the pros, cons, and limitations of those sources? With legal research in particular, there are obviously things like the paid services, Lexis and Westlaw, but there are many other, free resources now with Google Scholar and Fastcase that the Virginia State Bar offers, and a number of other different sources. There are pros and cons and limitations of all of those different various options. When I was in private practice, there was often a push to not use the Lexis and Westlaw because, of the cost. And so use the free resources, which were great. And if I didn't know where I was going to start, I would go to those free resources. But if I knew what I was looking at, it was far more efficient for me to get on Lexis and Westlaw and run a search, even if it was going to cost a small amount, compared to me spending hours of time at my hourly rate using the free resources. So that's where I think you need to be judicious about, what are the parameters? What am I looking at? If I knew, if I had some grasp or handle on the area that I was looking at, and I could tailor my search, and I could spend, a whole, session on how to do research and how to conduct effective research and how to create searches to get you the results you want, because that's an art that's sort of learned over time. But if you're able to sort of develop that art, then sometimes using those paid resources can be more effective. So at least think it through. If your client has put restrictions on sources, either because of financial constraints or just because there are limited resources available generally, my suggestion would be that you caveat your results and that you say, here's what I have done and here's what I found. With the limited time that I spent, here's what I found. If you don't have real clear sort of limits, the question of how much is enough research often comes up. And I think the answer to that is it's enough when you start seeing the same principles of law or sources or citations coming up in multiple times. Then you've done enough and you've covered your bases and you've found kind of most of the relevant stuff that's out there. I think everybody's sort of, at least for me, one of my biggest fears is, could I have missed something that was right on point? And I think the way to minimize that feeling is to start seeing the same stuff come up over and over again, because then you've kind of covered what's out there. So that's the where. Let's talk for a minute about the why. The why is this project, task, or assignment needed? And it's stepping back and getting a little bit of perspective, knowing sort of the forest from the trees, if you will, understanding where and how the work you're going to do fits in. If you can provide work, the end product, whatever that may be, whether it's a brief, whether it's a memo, whether it's an oral argument that you're going to deliver in court, if you can create that work product so that it is final and nothing needs to be done to it by your official or unofficial client, then you are going to make yourself invaluable. You want to make sure that what you're handing off can be used by someone else and doesn't need to be revised or reworked. If it needs to be revised or reworked, and the revision rework may be part of the process, but what you're handing off at the end of the day needs to be final so that it doesn't need to be revised or reworked. That's what's going to make you invaluable. And that really is the concept of sort of ownership. So when I was in private practice in the law firm, I was not ultimately responsible for any of these matters because I was an associate. The partner was. But at the end of the day, if I owned the matter or the issue like I was a partner and I was holding myself accountable for the results, that came through to the partners that I was working with. And they, in turn, they knew they could, over time, they learned they could depend on me and I was going to get it done, because that's their biggest fear, is you're going to hand them something that they then have. You hand it to them on Friday and it's due, at the end of the day, and they got to rework it, and they're out of luck. So at the end of the day, if the buck stops with them, they want to make sure whoever they're delegating to is going to take that ownership and responsibility. And if they know that, they are more likely to delegate the important, career sort of opportunities to you. While I was at the firm, as an associate, I argued 2 different cases in federal appeals courts, one in the D.C. Circuit and one in the Fourth Circuit, on behalf of paying clients. I would not have had the opportunity had the partner not given me that opportunity, because he knew I would handle it and rise to that challenge. Was I scared to do it? Yeah, of course I was. But I enlisted mentors. I engaged other people in different areas of the firm to help me to do moot courts, to practice mock arguments. And it really gave me an opportunity to, take a case I've been working on in discovery and litigated and won on summary judgment. When it went up on appeal, I was the one that wrote the brief, and then I was the one that argued the case. And that was an incredibly sort of fulfilling experience for me. And the reason, again, I got to do that was being able to sort of take that ownership of the end product. When I was writing those briefs, the partner knew he wasn't going to have to revise them. Yeah, he was giving me input, and I valued that input, and I would bounce ideas off of him to be able to make sure I was doing, creating the best argument we could. But I wasn't relying on him. Oh, it's his problem. I'll do the best I can and give it to him, and he'll fix it. So that's the why. Let's spend a few minutes talking about the how. I want you to think about how you will communicate the work that you're doing. Again, this is about thinking about the end product. Is it going to be verbal? Is that a presentation to the board? Is it an oral argument to the court? Or is it in writing? Is it an email? Is it a memo? Is it a legal brief? With a final verbal product, you need to think about word choice, tone, and body language. But even body language can convey if you're talking over the phone. So those are just a few things when you're talking about verbal work product. With written work product, my suggestion is to think about active voice, not passive voice. So when I was first sort of taught this concept very early in my private practice years, I had to sort of remember way back to things I learned in sort of basic English class. And for those of you who, like me, couldn't remember at the time, passive voice is John is employed by dollar company. Active voice is dollar company employs John. You're stating it more actively. You're using a verb instead of one of those is, was verbs. Active writing is far more persuasive than passive voice writing. Active voice writing is what tells a story. And it doesn't mean every sentence has to be an active voice. But if you can constantly, when you're writing, think active voice, even if you write it in the passive voice and then convert it over, which sometimes I still have to do, even though I've trained myself to write in more of an active voice, you are going to tell a story which ultimately will be more compelling. With writing, remember back to your legal writing 101 days. Use IRAC, the issue, rule, application, conclusion, but then vary it to make it your own style. So we're not in legal writing anymore, and we don't have to use issue, rule, application, conclusion. But if you can take that structure and tailor it to whatever you're doing, that's going to help you. That's kind of the foundation, if you will. My suggestion would be to avoid hyperbole, especially in legal briefs or motions. It makes you look more desperate. It comes across as smoke and mirrors and little substance. Proofread your writing. Make sure that it doesn't have grammatical errors or typos. Typos happen to everyone, but they don't reflect well on the person who prepared it. If you can't proofread your own stuff, and I have a very hard time doing it myself, try and get someone else to do it for you. Have an assistant, have a colleague look it over, just to catch something. If that's not an option available to you, build in extra time so you can put it away and come back to it. And if, as a total last resort, read it backwards, because then you won't be as familiar with it. When I am reading something that I'm very familiar with, I read it as if I think it should be written, not as if it's how it's actually written, which is why I would tend to gloss over the typos. So either getting some distance from it so you come back with a fresh perspective and are able to read it, or reading it backwards can help you catch those. If you have a choice about your end product, whether it's verbal or in writing, think strategically about whether it would be better to have it verbally or in writing. And that's not always going to be a choice you have, but if you do, think about what's your objective. If it's legal advice, do you really want it in writing? You might really want it in writing if it's legal advice, to say, look, I showed you and I gave you this legal advice, but you may not want it in writing, depending on what legal advice you're giving. It's also important to know your audience. Once you identify and know your audience, if it's a bunch of lawyers, fine. The legalese is fine. If it's not a bunch of lawyers, as I said, a lot of my clients are in HR, so they tend to speak, the employment sort of HR language that I do, but they don't speak employment law, and so I have to take out those legal, standards and legalisms that we use and really make it understandable. Explain what the concept is as opposed to just using the legal term of art. On the slide, the next sort of item is basically a triangle or an upside-down triangle. And this is the notion of how you communicate to your audience. With the triangle, do you start with your main point at the top, and then do you expand down and give all the background to getting to the base of the triangle? Or, on the flip side, do you start with sort of the broader and then ultimately get to your point? I can tell you that generally for my clients, the first, starting with the point and then explaining, is the most effective. Not all of them, but many of them, they want to know the answer, and then you can explain it to them. If you start trying to explain it to them and give them all the background and the rationale and reason, they're going to have tuned you out by the time you get to the point. So starting with the point can sometimes be the most effective, but it may not, depending on your audience. A couple of other approaches that I at least wanted to throw out so you knew they were options are prep versus answer. Prep is stating your point, giving a reason, giving an example, and then restating your point. Answer is grabbing someone's attention, explaining what the need is, putting forward a solution, and then ending with a call to action. It's important to know your client's writing style and preference, if any. Sometimes clients will have very distinct preferences, and you will want to tailor sort of your work accordingly. I want to have a quick sort of word of caution about email, instant message, and texting. And the word of caution is this, as we probably all know if we think about it. Once you send that email, instant message, or text, you lose control over it. So you are creating a record, and you want to make sure you're creating a record that you're comfortable with and can live with. It's the same sort of word of caution that applies, out there with the use of social media. You want to make sure that you're representing yourself and whatever it is you're saying or, legal advice you're providing in a way that you want it to reflect. So just carefully consider your format, context, word choice, and tone. Okay, so now I've hit on all of the different aspects of this approach to effective client service that I call WHA, the who, what, when, where, why, and how. I just want to spend, we're getting close to the end of time, I just want to spend the last few minutes really giving you a couple of my final thoughts on sort of the balancing act. The first is, building credibility and reputation. It's important to remember that it's a process. It takes what's the saying? It takes a career to build your reputation and an instant to destroy it. So it really is a process. It happens over time, not overnight. I think, as I mentioned earlier, don't be afraid to sort of show that human side. Don't be afraid to admit a lack of knowledge or mistakes. But here's the caveat. Commit to getting the information, answer, or correcting the mistake. So, there are many times, when I was in private practice, and I'm sure it still even happens now, where I would get home and I would think, oh my gosh, or I would wake up in the middle of the night and think, oh, did I do that? For example, when you're in litigation and you file a motion to dismiss, if the court denies your motion to dismiss, you have to go back and then file an answer within a certain number of days. I can't tell you, at least once, I remember in private practice thinking, oh my God, did I do that? Once I'd had that, I realized that later on, and I didn't end up sort of missing that deadline. But if I had, I would have dealt with it, and I would have said, yeah, I screwed up, made a mistake, but I'll fix it. I think that builds credibility. If you're able to show that you own up to sort of mistakes, that helps make you sort of come across as, a lawyer that other people can sort of respect. Just a quick word about diligence and cost. Cost is an increasing sort of factor that we all face as lawyers, but the rules of professional conduct and the professional guidelines also have this requirement that we provide diligent client service, and so we need to make sure that we are competent in the area that we're practicing and that we're diligent in doing the work. And so sometimes that may even mean, having to sort of do something that we don't end up billing our clients for because we need to make sure we're providing that client service, or giving a discount or adjusting in some other way. That diligence piece is really important, and that really, at the end of the day, comes above sort of cost. Lastly, but not of least importance, is the notion of sort of work-life balance. I am a firm believer in the importance of boundaries. I think you need to figure out what your boundaries are with respect to work and where they are between work and life. It doesn't mean they have to be rigid boundaries, but they can be flexible boundaries, but there need to be boundaries, and you need to figure out what works for you personally and professionally. I also would caution about multitasking. It is something that we all have to do. We do it every day. I was talking about the triaging and prioritizing. That's multitasking. However, I think there is a downside to multitasking, and I think sometimes multitasking makes us more inefficient or less efficient, if you will. I think that sometimes we can be more efficient and more productive and provide better client service if we cut down the multitasking as much as we can. We still may have to triage and prioritize, but if we aren't trying to work on multiple things simultaneously, we are able to sort of focus on that one thing, get it done, and move on to the next thing. That same concept applies to the distinction between sort of work-life balance. I try, when I am at work, to be at work and have all the things in place at home to make sure I'm not worrying about my kids while I'm at work. Likewise, when I get home, I try very hard to be with my kids so that they're and not on my phone or my BlackBerry. It happens every now and then. A client needs me and I have to respond. But sometimes I don't always have to look at it as frequently. I can do it in a way where I'm still being present and engaged with them. And I think that helps maintain those boundaries, and I think it helps give you more of a sense of balance. My last sort of word about balance is thinking about balance in a time increment that works for you. As lawyers, especially if you're in private practice, or especially if you're in a large law firm, the concept of balance in any given day is often elusive. I think that you need to think about balance over a different period of time, and whether that's a week, whether that's a month, whether that's a couple of months, may depend on your situation. When I was at the firm, for me, balance was over a period of 1 to 3 months. Over a period of 1 to 3 months, I would have balance between the amount of work I did and my outside life. However, it wasn't on any given day, and it wasn't even on any given week. Now that I'm sort of in-house and also have children, for me, balance is much more of probably a weekly occurrence, not necessarily even a daily occurrence. So it does change over time and circumstances, but I still think if you can think about it over a period of time, that might be a helpful concept. So with that, that's all I have. Thank you so much for your time and attention. I really appreciate it.
Thank you very much, Lesley. You can view more of these videos on the VSBYLC YouTube channel or on the Young Lawyers Conference website. Thank you very much.